Hi there, this is Erica Merrill, and I'm the founder of Perfect Legal Video, and I'm very excited to have with us today attorney Jim Sorenson. He is a partner at Sorenson Van Leuven law firm. They are out of Florida. They work with Georgia and Florida credit unions, and we are here to talk about some up-to-date, hot off the press information on the latest enforcement activity for the CFPB. I want to thank you so much for bringing this information to us today and being with us today, Jim. Welcome to the show.
Thank you, Erica. I'm glad you have me to talk with you today. Looking forward to talking with you about the latest enforcement activity by the CFPB.
Absolutely. So today we're talking about the CFPB stands for Consumer Financial Protection Bureau, for those of you that don't know. And we've discussed some of their rules that they've adopted and changes that they've made to try to help streamline the process and make the process better for consumers and for creditors. So let's talk a little bit, I guess maybe review that really quick so that we can move forward with the new information.
Sure. The CFPB in late last year in November, December, issued two final rules regarding debt collection activity. These were rules under the Fair Debt Collections Practices Act, and we've talked about those, and those rules will go into effect later this year, go into effect next November of 2021. And today we're going to talk about some of the other things that the CFPB has been up to besides just promulgating rules.
Can you tell us any of the other things that have been going on in the last couple of months? I know, we've got the updated rules. I know we're going to be talking about the enforcement of some of those rules, but is there anything else before we get into that we should know?
Well, there's been some other rules, there's been a lot of activity at the CFPB, and we would expect more activity in the coming year with the election now being over, and a new president is going to be officially in office starting next week. The CFPB in the coming months will probably change in leadership and be moving in a different direction. But kind of as the current leadership of the CFPB, they were wrapping up a lot of things in this past year, and so there have been some interpretive rulings issued and some other clarifications issued in addition to the rulemaking and the enforcement activity.
So what other issues have been raised in these legal actions or settlements?
Yeah, so the CFPB in December released 5 press releases regarding 5. These were either lawsuits announced against specific companies or settlements with specific lenders. And these 5 actions that all were publicized in December revolved around 6 different laws. The violations of the Military Lending Act and issues related to the Military Lending Act. They dealt with the Electronic Fund Transfer Act. They dealt with the Fair Credit Reporting Act. They dealt with the Consumer Financial Protection Act of 2010. They dealt with the Fair Debt Collections Practices Act and with the Real Estate Settlement Procedures Act. All of these are federal laws. They all have acronyms for their names. I just went through the long names, but these were all the various laws that were either alleged to have been violated by these companies, or the companies entered into a consent agreement whereby they admitted they violated these laws.
I think that this is one of the most interesting interviews, because everything that we typically talk about are, the rules and what happens theoretically, but we have some real life examples on this interview. So can you tell us a little bit about who's in which companies were involved in violations?
Yeah, so the 5 companies involved, and some of these are more, if you will, household names or better known names. Some of them are not. But Omni Financial of Nevada is one of the lenders that is involved. We can talk more about who they are in a second. Santander Consumer USA, they're a pretty large auto dealer in the American industry. They do lending out. There's a couple divisions of Santander that do lending outside the U.S., but this is Santander Consumer USA, so they're the one that operates within the country. Discover Bank, part of Discover Cards and all of that, is one of them. There's a smaller company called RAB Performance Recoveries LLC. That is one I was not familiar with until this announcement came out. And then NationStar Mortgage, which is a pretty good size mortgage servicer out there that is pretty well known in the industry, even if it's not a public name. All 5 of these companies were involved in these various legal actions by the CFPB.
Wow, that is so interesting. And what I love about the examples that you're giving is it just really shows that, a big company like Santander. I mean, we have Santander around me. Do you have Santander around you?
Yes.
Okay, so I'm way up north, you're way down south, both on the East Coast. And, I remember when they split and, Bank of America has half of the customers and Santander had half of the customers. And I remember that because my husband at the time and I had our accounts got split up, and I'm like, I was really glad that I got to keep my regular bank. But it's amazing that a company that big, you would think, wow, they've really got it together. They've got all of their processes spelled out. They've got their training. They're not going to make big mistakes, but apparently they have. So you think that they must have a team of people trying to help keep them straight, but I really think it's about having the right attorney. So I'll plug right now, if you are a credit union that is looking for someone that does keep up on these rules, obviously the Sorenson Van Leuven law firm is fantastic. So let's get into it. Let's talk about the issues of national mortgage. What happened there?
Yeah, so NationStar Mortgage, like I said, they're a large mortgage servicer, so they service mortgage loans. And in this case, the legal action that was announced and the settlement that resulted was really a coordinated effort. It was the CFPB working with several attorney generals from various states, along with state bank regulators. So you had 3 different governmental entities involved, really more than that when you consider each state attorney general being a separate governmental entity. The order involving just the CFPB required NationStar, or will require NationStar, to pay over $74 million in damages. That's not what. Also, there was additional orders that involved the state attorney generals and the regulators. So in all, it was significantly more than $74 million. But for the purposes of this, we're just concentrating on the CFPB part. So as you can see, this is a significant expense to this company. And the activities that were involved here involved failing to identify loans that were in a loss mitigation process. So these are loans where the borrower has fallen behind in making their payments. They have applied for loss mitigation help, meaning they're looking to save the home and get back on track. And the servicing company was not properly marking those accounts and not treating them properly under federal law. And then where they entered into modification agreements or other loan loss mitigation agreements with the borrowers, they were failing to honor the terms of those. They didn't update their software to reflect that maybe the payment changed or the due date changed or whatever the term that changed. They were making representations to borrowers that they would not initiate foreclosure against them, and then they were initiating foreclosure. They were improperly increasing the borrower's payments. They misrepresented to the borrower when they could cancel their private mortgage insurance, and they failed to remove private mortgage insurance from borrowers' loans when they were eligible to have it removed. They failed to timely disperse tax payments from their escrow account. So where the consumer's part of your typical mortgage payment is to not only pay the principal and interest on the loan, but you make payments towards the future tax payments, the future insurance payments. So people's property tax bill would come due, and Nation Star had collected the money, but they were failing to pay the tax bill. And then there was also some issues with the bankruptcy and failure to properly conduct escrow analysis of borrowers who were in bankruptcy. So really a laundry list of problems that they were having, and really most of this all falls under what we commonly refer to as RESPA, a federal act that deals with real estate settlement and procedures. So
I'm almost speechless. I mean, I just closed on my house, and I did a refinance, and I just remember that when we're going through all this, really the property was being transferred from my ex-husband to me, and there was a little bit of there's escrow, and that's to pay the property taxes. And I'm like, well, who's going to get that? Because I've been paying for the last 6 months. And, there was a little bit of I was nervous that he was going to get it and I wasn't going to get my money back. But, I never even thought of the bank not having the money because they spent it, and you're not supposed to do that. That's amazing that happened. And you're right. It sounds like a laundry list. I'm mortified. What about this concerns you when it comes to your own clients? I mean, I know that you make sure that they are shipshape with all of this, and it really sounds like that company had some ill intentions, and I know your companies don't, but I'll let you weigh in.
Yeah, no, I do think some of the things that they were doing are so egregious that it's hard to understand how a functioning company who wants to comply to the law ends up in that position. But the thing that concerns me for my clients, and kind of what you can take from this, I think, and apply it to any lender, is probably the last thing on the list, because it is more of a technicality. It's one of those things where there's a misunderstanding in the law, and I think the CFPB was trying to clarify that, is the issue with bankruptcy and mortgage loans. There's a lot, whenever we deal with bankruptcy, there is always sometimes a lack of knowledge and a lack of understanding how regulations come into play when a borrower is in bankruptcy. And in this case, the issue was failure to properly conduct an escrow analysis of mortgage loans that are in bankruptcy, in particular Chapter 13 bankruptcy. And the regulation says that if a borrower is in bankruptcy, the lender is not required to provide an annual escrow statement to the borrower. What people have taken that to mean is, well, because I don't have to provide the borrower the statement, that means as a lender I don't have to do the escrow analysis, and that is not true. The regulation is clear, or should be clear, and that's really what CFPB is trying to do here, is make it clear that regardless of whether that has to be provided to the borrower, every year the lender has to engage in the escrow analysis. And in this case, Nation Star wasn't doing that. and so they got in trouble. And so, my advice to my clients or to credit unions out there in general, or any other lender out there who services mortgage loans, is to make sure that even those loans in bankruptcy, that the annual escrow analysis is being done and is being handled correctly. The bankruptcy doesn't alleviate your duty to do that every year.
Yeah, I mean, I think you're right. And it feels like, sometimes people just get in a groove with their process, and, they remember things a certain way and they just keep going. Or maybe they hire a new person and there might have just been a change, but somebody else who didn't know about the change yet trains the new person. And that's when mistakes end up happening over and over and over again. And I know that we've spoken about this in the past, where you can have huge lawsuits because the same mistake was made over and over and over again to hundreds or maybe thousands of people.
Yep, that's exactly right. And I think, I think it's exactly what you said. You get in a rut, you get in a groove, and there's assumptions being made that things are being done right, and no one's checking to make sure they are being done right.
So let's move on to the next one. But what I find interesting about what you have lined up today is the issues are all very different, and it really delineates a full view of, some of the things that can happen when you go and you make mistakes with these new laws. So let's talk about what happened with the RAB performance recoveries.
Yeah, so RAB is an entity that purchased debts and collected on those debts it purchased. It also apparently collected on debts that were also owned by third parties. So they acted like a debt buyer and a debt collector. And they were collecting debts against consumers in states where they weren't licensed to do business. In those states, they're contacting consumers, demanding money, and they're representing that if the consumer doesn't pay, they're going to file suit against them. And legally they weren't entitled to do that because they weren't licensed to operate in those states, and they weren't licensed to, as a result of not being licensed to operate in those states, they had no ability to file suits or take legal action. So, to me, this is a reminder that when a credit union or any lender hires a debt collector, it needs to make sure that the entity they're hiring is properly licensed to do business in the state where it's going to collect. It's surprising, but you would think that that's common sense, but there have been times where, I have been brought into a situation, or another lawyer in my firm has been brought into a situation where a client has hired somebody and no one bothered to check whether that company was licensed to do what they were doing. And now a legal issue or a red flag has gone off, and this issue is discovered. So, it's just, again, this is a reminder, and, I think these cases serve as a warning. I kind of heard it this way. In life, there are things we call stupid taxes. You make a stupid decision and there's a tax, there's an expense, if you will. And the way I look at it is we're learning from other people's stupid taxes, and we're letting them pay the stupid taxes and learning from it. So hopefully that's what we're doing here, is kind of highlighting how to avoid paying the stupid tax, at least in these scenarios.
I mean, I think that is so smart. And, last interview we had, we talked about when credit unions have to outsource their collections, and you did give a bunch of fantastic tips for how to hire the right people for that job. And I'm sure one of the first simple things is like, what's wrong with my computer? Well, why don't you plug it in? Like, why don't you check the license?
Yep, that's exactly right.
So let's move on to Discover Bank.
So Discover Bank, in this case, the issue here was student loans. So the part of the Discover, if you will, financial empire that the CFPB was focusing on was the part that dealt with student loans. And what's interesting here, and this is another one where you know, it's almost when you read the facts and you get into the facts, you're almost like, how can a big company like Discover do this? So here, Discover had been violating the law and entered into a consent order with the CFPB in 2015. So 5 years ago, they entered into a consent order. They paid money. They paid a big multi-million-dollar fine. They agreed they were going to do X, Y, Z. And now the CFPB comes in 5 years later, and they're still violating the law. And so here the issue was they were misrepresenting loan payments that were owed. They had incorrect information on the interest the borrower had paid, and that was impacting the borrower's ability to file their taxes. They had other pertinent loan information that was misrepresented or inaccurate, and they were failing to properly handle consumer complaints. So as consumers complained about these issues, they were given the runaround. And part of the consent order in 2015 was they were going to improve the consumer complaint process so that when consumers had a complaint, there was a quick and easy resolution. That all seems reasonable, and Discover Bank agreed to it, but 5 years later, they still weren't doing it. And kind of, again, surprising to me that a big company like this would be in this position.
I mean, it really is. And I mean, it just goes to show, sometimes when companies get big, one hand doesn't know what the other hand is doing. And these are some really great examples.
Yes.
So what are some of the lessons that we can learn from that? I mean, it sounds like they were on the right road and then the ball got dropped, and 5 years later, now they're in hot water. Is there anything that you think you can pass on to your clients and viewers, just to give them some tips on how to help avoid this situation?
Yeah, I think so. I think this is the reminder of the need for constant inspection, and to make sure you have a robust process for handling consumer complaints and for tracking those complaints. I assume what happened was Discover addressed the issues 5 years ago, and then slowly over time, everything returned to what they were doing before, because they thought they fixed it and they forgot about it and moved on to other things. And, instead, what they should have been doing was every so often going back and saying, okay, we corrected it, but is that corrected behavior sticking? Are we still seeing the same problems? And then certainly when it came to the handling of consumer complaints, no one was paying attention to what was happening. And so when the same complaints kept arising and the same issues kept arising, there was no red flag, there was no bell that went off that said, oh, maybe our process isn't working. And so, again, I see this over and over again. A lender gets in trouble, whether it's like the CFPB here or they get sued in a lawsuit, whatever the case may be, and the problem is identified. They work to correct the problem, but 5 years later, that problem has crept back into the organization. It's crept back into their practices. And no one has taken the time in those 5 years to evaluate, did the change we make 5 years ago stick? And so, it's that consistency, it's that inspection that has to happen on some regular basis to make sure that management, what they expect to happen, is actually happening. And it's a basic management principle, but yet it's one of those that we fail to follow over and over again.
Well, I mean, what I love, and it can happen to anyone, but what I love is that saying, inspect what you expect.
Exactly.
And I think too, it makes sense to have checklists, but I also think that, like, for your clients, a lot of them hire you training every year, and you've probably got a list of the things that they need to look out for and the updates and everything else. And you can go and do an audit on some of the systems and processes that you put in the past. And I mean, I'm just guessing, you haven't told me about this. I know about the training, but I don't know like what kind of auditing you might do every year. But that's what people hire you for, partially. Am I right?
No, and we do the auditing. Part of that is what we do. It doesn't, to inspect what you expect, you don't always have to hire a consultant. But there are times where hiring a consultant or hiring an outside professional is beneficial. And so that is part of what we do. We come alongside and help our clients inspect what they expect to be happening in a particular area of the credit union, to make sure these things aren't happening, that the changes that have been put in place have taken root, that bad habits have not reformed, and of course the training is also a key part of it, as you point out.
I mean, that's what I love about your firm. It's not just a law firm. When you get in trouble, you call these guys. It's really a lot about preventative and about maintenance on the processes that you set up. And I really think that's the only way to go. I mean, you save your clients millions and millions of dollars on mistakes that just don't happen because they have you to keep the things from blowing up.
That is our goal, to partner with our clients and to prevent mistakes, not just to be there when a mistake does happen.
I mean, I'm not trying to be a commercial, but I wish that I had someone like you in my life, but I'm not a credit union. So let's talk about Santander, because I think that that's a really interesting situation, and another big mistake that we can, there are many mistakes I think that they've made that we can learn from. So let us know about what happened in that situation.
Yeah, so Santander, as I indicated, Santander is a large company and they have several divisions. So the division here that we're dealing with is what's called their subprime division. So this is the part of the company that makes auto loans to borrowers who have less than good credit. These are the higher risk loans. They tend to be higher interest rates, higher payments. In this case, what the issue was dealt with their credit reporting. So like all lenders, they reported their consumers' credit activity to the credit bureaus, to the credit reporting agencies. And in this case, the CFPB found what they called, and I quote, many systematic errors. They didn't give a quantity of what that was. I don't know what the error rate was, but you get the sense this was not the one-off errors, that there was repeated errors in the information they were reporting. And the errors included incorrectly reporting when loans were open or closed, meaning whether the loan was still an active loan or it had been paid off. In some cases, they were showing a borrower or a consumer owing money when they didn't, or that the consumer's payment terms were different than what they were reporting. And all of those things impact a person's credit score. So, if you're reporting wrong, if you report on somebody that they owe $600 a month on this auto loan and they don't have that auto loan, that is going to negatively impact their credit. Now, there's a lot of factors that input into their credit score, but that is going to probably have a negative impact on their credit. And the CFPB has had for a long time this focus on credit reporting and concerns that lenders aren't taking this seriously. And so, every year we see creditors who have failed to report credit properly, and the CFPB makes an example, and Santander in this case happens to be the latest in that case.
I mean, they can get in a lot of trouble for that. I mean, you're right. It's hooked up to somebody's credit, and I know people even hire attorneys and certain companies to just keep track of all that. And so if you don't have that, your credit could be going lower and lower and you don't even realize it. And it's all because this bank did not do what they were supposed to do with the reporting.
Yeah, that's correct. I mean, not only are they facing the issues with the CFPB, but individual consumers probably have sued them over this. So it's a big deal.
Yeah, it's a big company. I mean, you can imagine how many times it probably happened if it was already happening. Anytime a mistake happens with a bank, you can assume if it's part of a process that was going wrong, that the mistake happened a lot. So you just think about all the lawsuits and how much money that can cost. It can really bankrupt a bank. I mean, I know that we've talked a little bit about this before, but they're a business like anything else, and they can either go under or be swallowed up as a result of a huge mistake like this that gets repeated.
Yeah, no doubt. The cost of non-compliance, especially in this area, could be just significant and could impact the viability of the company moving forward. I don't know that particularly in Santander. I'm not familiar with their financial position, but as just in general, yes, it's you're risking the livelihood of the company if you're not following the law here and opening yourself to all that liability.
Exactly. So what can we learn from Santander? What are the lessons that you'd like your clients and viewers to take away?
Yeah, so I think again with Santander, and I've spoke on this before, I've stressed this before in other communications to my clients, and it's just the importance of a well-drafted procedure that deals with credit reporting and credit disputes, and then that those procedures are tested for compliance, meaning, if we get a complaint, are we looking at whether the complaint is justified or not? Was there a mistake? And if there was a mistake, is it a one-off situation, or do we have some sort of systemic problem? And if there is a systemic problem, how quickly are we moving to correct it? And what I find is that there's still a lot of creditors out there who don't even have the first step, which is the good procedure, the good process in place. So it starts with the procedures and process, and then it moves from there into what we've already talked about, which is, are we testing, are we confirming, are we inspecting that the procedures are being followed?
Absolutely. And I think it's great that you have somebody watching your back and keeping you on track with all of these things, because it's just not worth losing your business, just making assumptions, trying to cut corners. You just don't know. And it's such a shock and a horrible situation when you didn't check things out, or you didn't have somebody just analyze it once in a while and make sure that the processes were correct. So let's talk about our last example that you have for us. What happened in the case of Omni Bank?
Yeah, so Omni, according to the information provided here, and I was not familiar with this lender, Omni focused mainly on military loans to people in the military, but there was also consumers around the military. So their marketing strategy seemed to be towards active military people, but it would include family members, spouses, significant others of the military and retirees of the military. So for those that were in the military, as a condition of receiving a loan from them, and in most of these loans, as I understood it, were unsecured loans. As a condition for receiving an unsecured loan, they required the consumer, the person in the military, to agree to an allotment of their pay for repayment of the loan. And an allotment is like a payroll deduction. It's called an allotment in the military. And such a requirement violates the Military Lending Act. It's a fairly new law. It's a law that went into effect a couple of years ago, and the aim of the law was to protect those in the military from what was considered to be certain predatory lending practices. And one of those is requiring that in order to get credit, the consumer, the military member, has to agree to have their pay allotted for the payment. Now, certainly a military a person can choose to pay their loan through allotment, but you can't require it. And so they were doing that. And then in the case of individuals who were not in the military, what they were doing for those individuals were they were requiring that they provide their bank account information, and that if they failed to make a payment, they had already given in the loan documents authorization for Omni to deduct the payment from their bank account without knowledge that that was happening. So if your payment was due on January 1st, and the next business day, January, whatever the next business day, this year that would have been January 4th, Omni would have been able to take the money out of your checking account without telling you, calling you, or asking you. And that violates the Electronic Funds Transfer Act. So it violates another law. Under the Electronic Funds Transfer Act, you cannot require a consumer to pre-authorize what's called an electric fund transfer as a condition of receiving credit. So in this case, you have what appears to be two blatant violations of federal law, clear black and white. I don't know how else to say other than it appears to be a blatant violation of the law.
And it sounds like, gosh, if I were a business, I would not want to be messing with the military personnel and doing the wrong thing by them. It for some reason, it just seems that much worse. So I think that that's great that you're letting us know about this. What should credit unions know? What can they take away from this situation?
Yeah, so, I think, like I said, these actions of Omni seem somewhat intentional. I don't know. That's my opinion. But, it would seem that they either failed to get legal advice when they launched these lending programs. That's my assumption. Someone came up with an idea, no one checked to make sure it was legal, and they just launched it. And I think the takeaway is to make sure that when you make a new offering, when you offer a new loan, when you offer a new product, has it been reviewed for compliance with existing law? I mean, the law is constantly changing. And, what may have been legal 2 years ago, 3 years ago, 4 years ago has changed in some cases. And so unless you have timely, up-to-date legal advice, you're running a risk of violating the law. And again, in these cases with these laws, it doesn't matter whether you know it's illegal. If it's against the law, you're in violation. There isn't a knowledge, you're deemed to have known the law. So that's really, I think, the takeaway from the Omni case.
Yeah, and I think you're right. I mean, in most cases, I'm sure that the bank or the credit union involved has the best intentions, and they just didn't update their practices with the new laws that came out. And whether you do it or not, whether you know or not, it is still your responsibility to follow the rules and the laws. So they don't care that you had good intentions. Am I right?
That you are right.
I mean, if we could get away with that excuse.
Yep. Unfortunately, it doesn't work that way. Good intentions aren't going to save you in these cases.
I know. My 7-year-old tries to use that all the time.
Yep.
So is there anything else you'd like to talk about today before we go? We've covered a heck of a lot, and it's fantastic information for the viewers out there. Any parting words?
Yeah, I think as a parting word, I would just say, compliance is an ongoing process. The law changes, your process changes, your people change, your organization changes. So compliance has to be this ongoing process. And so, I think sometimes people get in the thought that it's a one and done thing. Oh, we looked at it, we're in compliance, we're good. And it's not that simple. It needs to be looked at as ongoing. It needs to be part of that process is that timely inspection. And how often you inspect something really depends on what it is, maybe what the level of exposure is, how you institute corrections, how you follow up on those corrections and adjustments, and that's part of what we do. We work with our clients to make sure they have good processes and procedures in place, to improve their process and procedures or help them put ones in place if they don't have it. And then we can work with them on helping how do they inspect the process and how do they improve it, or how do they deal with potential shortcomings in the process. And that is all, part of the services, the legal services that we do and how we partner with our clients. So.
No, and I know you do a fantastic job. I am your videographer. I talked to all of your clients and got great testimonials. So that's why I speak so highly of you and point out what you do in these interviews, because I think it's just fantastic. And the credit unions that have the foresight to hire you and take care of things the right way from the beginning are just that much further ahead of preventing any issues, any extra fees and lawsuits and all of that. And an ounce of prevention is worth a pound of cure. And, I really think that you help your clients with that. So thank you so much for coming on today and taking the time to go over so many examples of, different things that can happen with these new updates in the law. I just think that the information is invaluable.
Thank you for having me today, Erica.
You're welcome. We will see you again next time.